Hi, hello, Telugu, welcome to Telugu NRI Radio Facebook Live on USA immigration. So today is a very interesting subject and topic. Our attorney bring lot of news, big news to all H1 holders and L1 holders. So we can discuss today on this one, and I think just we got one information about the iSkill 1044, the bill S386 bill got passed in the senator, but not confirmed yet. But we will discuss this new bill too with our attorney. So let's welcome to our attorney Lucas from Burgos Garritson Law Firm from Dallas. Welcome, Lucas. Welcome today Wednesday show, live show. Welcome to Telugu NRI Radio live web page.
Thank you, Venkat. It's good to be back. Hope everyone had a wonderful Thanksgiving holiday. A lot of things have been happening over the past 2 weeks, so hopefully we can get everyone informed today with today's show.
Yes. So I think last week we did not do the show, but this week we brought the good news. Let's say it means we want to hear from you. Please share the good news to our viewers.
Well, as we discussed over the past few weeks, this new rule that was going both for Department of Labor and for Department of Homeland Security was found to be a violation of the APA, and therefore a judge in the Northern District of California has suspended or revoked the rules that USCIS implemented. And what this means is we've already felt the effects of the wage increase for all four wage levels, depending on where you're working. And the proposed new rules for limited duration, employer-employee relationship, third-party offsite employment, which is supposed to take effect next Monday, the 7th of December. Both of those rules are now suspended. And like we discussed on the show, we didn't think that they would be approved or be found to be in line with the rulemaking process because there was no notice and comment period made for either of the proposals. And what this means is anytime we have a rulemaking procedure or some change to our regulations, we have to have a period of time to where we can have a option for the public to comment on what these changes might be, how they might affect business or individuals. And then, the agency has to review these comments. And to bypass that, there's certain circumstances where the government can do this. And what the administration tried to do was to, rely on the COVID-19 pandemic to try and push these rules through any type of notice or comment period. So very happy. We're, hopefully by this time tomorrow, the DOL flag website will reflect the changes. So everyone can get back to filing LCAs, extensions, amendments, change of employers, and so forth.
Yeah, Lucas, this is a really good news for everyone who are waiting for the extension and amendment. Even so, we discussed a couple of topic and of H1 holders. They're eagerly waiting for these changes. It means court decision, so they can apply the amendment and the extension. So, Lucas, we are talking about the interim final rule. It belongs only to the prevailing wages, or it all included whatever the new changes, regulation happened on October 8th, October 6th. All those all revert back to previous wages, or whatever the previous changes?
Correct. So each year, the wage levels are set based upon surveys and research done by Bureau of Labor Statistics to determine what the appropriate wage levels are for the MSAs or metropolitan statistical areas for whatever job category SOC code. that might be, as long as the area where the work would be located. So that's conducted every July 1st. It's when it's published each year. So the fiscal year would be, July 1st to June 30th of the following year. And, now everything is going to revert back to what happened post July 1st this year. So it might take a day or two for the systems to, fully integrate and go back to the database the way it was set up with the other wage levels. But it should be a pretty straightforward process, because it only took them, a day or two to upload all the changes. It should be a day or two to change back.
Okay. Lucas, I have a question about the specialty occupation. So recently, October 6th, USCIS defined the specialty occupation. Can you give them more information on that? This court is also ruled out those specialty occupation, or still the USCIS is considering whatever the pursued the degree, they want to do the same segment of career?
Well, that's another good question. So the IFR, the interim final rule, basically would cover two agencies: Department of Labor, which we just discussed about the wage level increase, and Department of Homeland Security, which would encompass underneath that umbrella USCIS. So both of the rules, or both parts of the rule, were found to not be legal, so to speak, underneath the APA. And therefore, both, even though the USCIS part of the rule, or Department of Homeland Security rule, has not taken effect yet, it was set to take effect on the 7th, but now both of the rules are going to be suspended and not, eligible to move forward. Now, the government does have an option to file an appeal. Now, what would this mean? Well, if the government does file an appeal, it would have to show that, the underlying district court didn't have the proper authority to issue the injunction based upon the merits of the facts of the case that were presented. Now, to do this, one would have a difficult time depending on which circuit court you start with and which appellate court you would be assigned to. So in California, where this lawsuit was decided, which is in San Francisco, it goes to the Ninth Circuit. And the Ninth Circuit is probably one of the more liberal courts within the United States. So the chances of an appellate court rescinding the injunction and remanding it back to the district court to move further without the injunction would pretty much be a very small percentage at this point of that happening. So it looks like the timing of the procedure and process to get this done, along with the end of the presidential administration, which we're just about 1 month or a month and a few days until we have a new president. It looks like it's very favorable to us for this rule to not ever really be legally filed or put into the regulations to be enforceable. Because when the new president comes in, he could just simply say, I no longer wish to appeal this issue, and they could drop the case at that point in time.
Okay. Excuse me. So Lucas, in IFR on October 6th, the USCIS released the three rules. Another rule is the short-term approvals. If any H1 holder working in third-party companies, maybe we heard only will get the only one year of approval. So hopefully, this is also ruled out. Everyone get the 3 years extension H1, right? This is correct, or?
Yes. So that's basically what we just said. There's, for the DHS rule, there were three main parts to it. You have the employer-employee relationship, which they were trying to reestablish as part of a requirement in the regulations for H-1B visas. You also have the 1 year limit on the validity period. So up to 1 year being authorized instead of the 3 that was issued by statute. And then also what we call the third-party offsite employment, where we want to show all the contracts, work product, client letters, vendor letters, and all that, was also tried to be included in this. So there were 3 parts to the DHS rule. And now, since the judge has thrown that out and suspended the implementation of this rule, we don't have to worry about that at the moment. I think you're on mute, Venkat.
Sorry. I'm sorry. Yes, I'm on mute. So, Lucas, I saw a couple of websites is saying that the iScale 1044, the bill is S386, got approved in Senate. Do you have any information from your attorney groups or this bill got approved?
Actually, I haven't heard anything. For our attorney groups, specifically, you're referencing AILA, American Immigration Lawyers Association. We haven't heard anything through our newsletters or anything like that, or message boards today. Now, I went ahead today prior to the show just to check. Representative Mike Lieu from Utah, I think, is sponsoring senator for this bill. And we didn't see any press release or any notification from that. I also checked the official page for the Congress, and it shows it's still pending in the Senate. So, there's probably a chance it could have passed. But as far as the formalities of proper notification and announcement, I don't see anything at this time. Doesn't mean it hasn't happened yet, but I haven't seen any news to reflect that we can confirm that.
Okay. I think this bill got held by the Democrat Senate or Republican Senate currently.
So the Republicans have control of the Senate, and we have Mitch McConnell, who's the Senate Majority Leader. And we're entering a term right now, post-election, but prior to the start of the new Congress. This is what we call a lame duck, which means there's not much authority for Congress to act. Now, the other day, due to the extensive need for a stimulus package due to the COVID-19, I think there was another, the second part of the CARES Act was passed into law. But as of this moment, I haven't heard of anything else really moving, and most likely nothing will really happen until the new administration comes in, new senators come in, and a new Congress is established. So at this point in time, it would be kind of a unique situation to say the least, if something like that did happen. So I would lean more towards caution before believing that this passed. Now, remember, even if the Senate approves and forwards the bill, unless they have, a certain majority, a supermajority on that, the president can still veto the law. So we'll just have to wait and see.
Okay. I think this bill will expire by December 2020. So do you, I think, yes or no?
Yeah, I mean, there's a shelf life on these bills when they're put through the process, okay? And when they're introduced, and if they're not passed through committee, or they're not various other administrative or procedural issues or processes don't take place, then they'll time out or lapse. So it's not to say that it's the end of the line if we get past a December 20th date, that it can't be reintroduced or removed. But like we were saying for many weeks, especially going back a month ago or 2 months ago with the visa bulletins, I really believe, the focus should be on comprehensive immigration reform. And I actually think that we're going to receive the better hope of something happening through new legislation rather than what's already pending. What this means is, the Congress has the opportunity to where they can address many other issues many other problems within the system, and make sure it's a well thought out process for all facets of immigration cases, rather than just the backlog we have here. So, I think in all fairness, the best thing to move forward, the best hope of anything happening is going to be through comprehensive immigration reform with the new administration, the new Congress, hopefully coming up here in a month or two.
Okay. Lucas, before going to the next question, I'm requesting to all viewers, if you have any questions, maybe you can post in Facebook page, so it get an opportunity to ask your question and get more information from the attorney Lucas. Lucas, just we can step into the December visa bulletin. So we saw the little bit changes. His final action date is moved a couple of days, and filing date got EB3 got retrogressed to the January 1st, 2014. So is there any additional information apart from this visa bulletin?
No, there's nothing really new other than the retrogression of the date. Now, I would like to take a moment and just, remind people that due to the amount of cases that were probably filed, we're still pending receipts. I've received case receipts for people who filed that required a supplement J. Now, I've heard from other attorneys and, within our own message boards with AILA that anyone who downgraded or filed an I-140 along with the adjustment, there's been quite a few delays with USCIS on generating receipts for those cases. So hopefully the next week or two, we'll start seeing those cases progress and come through. But as of right now, there's nothing really new with the visa bulletin. And, everything's just real slow processing as far as the receipts go.
Okay. I think whoever applied and before October 20th, they got the receipt number and fingerprints dates. But after October 20, still they did not get the receipt number. When they can expect the receipt number? Next couple of weeks?
It just depends. So like I said, there's a few factors involved here. If you filed an adjustment of status and you were, let's say you're EB2 and you're with the same employer and you filed just a supplement J, well, there's two ways. There's two service centers that you would file to, or lock boxes. Each one might process faster or slower. Anyone who filed an I-140 downgrading with this process, they only go to one service center. So it goes to the Texas Service Center. So if you can imagine in that one group, maybe of 20,000 possible people filing adjustment at once, I would estimate that at least 80% is going to be downgrade cases included. So it's just a matter of, the workers at that facility processing everything. And, hopefully here this week, next week, we'll start seeing some receipts.
Okay. Hopefully, everyone will get the receipt number as soon as possible, because some of H1 holders, they want to expedite the process. Maybe whoever downgrade EB2 to EB3, they want to proceed the faster, maybe expedite process. That's why some of are waiting for the receipt number. Lucas, we can go for the next segment, H4 EAD. So can you give about the H4 EAD? It means we saw a lot of issues from the past 6 months. The entire H4 and H4 EAD process got delayed. Even whoever applied the H4, still they did not get the receipt. Maybe they got the receipt number, but they did not get the biometric. So due to the biometric process, their petition is not going to the next step. It hanging the biometric stage. So this is affecting the lot of the employees who are working right now. It is impacting. It is impacting. So because the employer is not holding their employment, So can you give me what is the reason to delay, and is there any way to expedite the process to get the H4 EAD?
So, what you're referencing is an issue that we've encountered, probably for a year and a half now. And it's progressively become more and more of a backlog, in part, due to the pandemic. A lot of the in-person appointments were canceled for, 2 or 3 months with USCIS. So to give you, a little bit of a background, what we used to do is if, let's say if I was filing an extension for myself and I wanted to file also H4 EAD for my spouse, and I filed my case in premium, prior to the biometrics requirement, we could pretty much anticipate my case would be, approved within 2 weeks, and pretty much within the same week or the week after, the H4 EAD would arrive. When USCIS implemented the biometrics process, you have to remember, we get the receipts, everything's generated, and then depending on where you live, USCIS will assign you to go to a local, facility to do the biometrics. So here in Dallas, there might be 1 or 2 locations where you go. If you live in Fort Worth, there's a different location you would go to. If you live in Atlanta, et cetera, et cetera. So depending on how many other people who live in that area would use the service, it depends on how fast you might have an appointment. Now, what compounds this is when we had, I believe this March, USCIS, closed all of the appointments and interviews for biometrics. And what this has done is caused a tremendous backlog. So, in the system that traditionally is a first in, first out process, it hasn't been that way. So I've seen people, some we file like maybe in June or July, they'll be, able to get their biometrics appointment prior to someone who filed in April. So it's been an odd process, and it's been a huge delay, to say the least. Now, going to phase part 2 of your question on the part of expediting, due to hardship, the filing of and the approval of the H4 EAD, you can show the process is one where you would have to call in and make a service request. The service request would come back in the form of an email. In the email, you could supplement evidence and things like this and address why it's important for you to get the expedited request. Now, here the past month and here again recently, USCIS has changed their phone system where it's very difficult to even get to a live person to discuss anything, a level 1 officer. So because of that, it's hard to get it into the queue to have this request made so you can have this, expedited. So it's been very much a headache, and it's every day it's a changing process. So if anything, the process has become more difficult rather than easier. And so hopefully what we can see is someone addressing this in the near future where maybe we can use existing biometric information to just rerun the data and see, running this in databases to see if there's any changes. Maybe that will help speed up the process, or maybe eventually we'll get caught up and pass the backlog so the times, go back to more of a normal processing time.
Okay. Lucas, here I have a couple of questions on H4 EAD. Even so, I got a couple of inquiries about the expedite H4 EAD by using the litigation.
Yes.
What is the litigation in immigration system?
Well, the litigation is you have a few different types of recourse. Primarily what we're talking about here would be a mandamus action where we're going to ask the court to make USCIS, the agency, perform a function that they should perform in a timely manner or without delay. The problem is most of the time for the H4 EAD, unless you're pretty much, unless the H4 is already approved, it's hard to do a mandamus action unless it's outside normal processing times, unless your H4, you receive notice it's approved, but you haven't received the card. That would be one way of showing, a lawsuit, USCIS. Now, when we're doing these actions, we have to show that there's undue delay and things like this on the part of the government. And, it's possible to do this, but, you can't really, it's more difficult to move forward with a case if you're only waiting 6 weeks rather than half a year, so on and so forth. So every case is somewhat unique in the sense we have to look at the surrounding factors, the evidence that surrounds each case to determine what's going to be a successful case and what's potentially not a successful case at that moment to pursue litigation.
Okay. Let's say if any H4 holder want to expedite by using the litigation, when can they start the process? Let's say one of H4 holder applied 3 weeks ago. They got the receipt number, but they did not got the fingerprints. So if they want to expedite by using the litigation, will it work?
Probably not. And just to clarify, so a lot of people this last year might have used a process where there was litigation for an expedited process. That was a group of people who filed a lawsuit. And the lawsuit was to focus on, long delays and things like this. So if you were a member of that group and you could join later, then it was possible to maybe get this moving faster because you were a part of a large group. So if there was a situation like that again, where you had a large number of people pursuing litigation with a certain issue that was ripe at the time, or focused on a new issue that might have come up, then that would be possible. But going one by one, it's very unique and specific for each individual, and you would really need to show in a mandamus action, and that is in that sense that there was undue delay, that maybe the case was approved, but you haven't received the card, that there were delays like that. So, like I said, it's very specific to each individual's case. And if there is a group litigation effort like there was last year, that's something that if whoever the attorney is handling that litigation will be able to say, we want to include you, or these are the factors or background of your case that you would have to match what we're doing here. So.
Okay. So the expedited process only the litigation, or is any other things?
Well, at this moment, what we would want to do is hopefully have the new administration, like we've discussed with comprehensive immigration reform, where there's over 30 categories for employment authorization. Okay, one of which is H4 EAD. Now, since another is if you're filing for adjustment of status. So we have one category for adjustment of status, which is C09, and we have H4 EAD, which is C26. Okay. For C09, once your employment authorization expires, you can continue working on the receipt for 6 months, pending your new EAD card. For H4 EAD, where this becomes difficult, is you cannot work on the receipt. You have to have actual renewed card in your hand to continue your employment after your other card expires. So maybe there's something that can be addressed where everyone who has employment authorization can work on the receipt for 6 months pending the new card, or some change to that effect. Okay. But at the end of the day, the best news we've had, along with some of these recent court cases, is that it seems that H4 EAD is going to be safe. It's not going to have much more of any threats of being revoked or tried to be taken away. So even though it's a bit of a headache and it's precarious at times as far as going through this process, at least that option is there for people who want to choose to file H4 EAD.
Yeah. Here, just one information: C09 is EADs belongs from the adjustment of status as a green card process. The C26 is H4 EAD. So
correct.
The C09 they can work on receipt number, but H4 EAD cannot work on the receipt number.
Correct.
Yeah, it means, yeah, Lucas, I saw the one scenario. Is not a H1B, is a L2 EAD. They applied in before pandemic, before closing the service center. It means before April. So they applied the petition, but some reason it got RFE on primary application. So as of now, they did not get the biometric. So after it means other one applied after pandemic, maybe May or June. They got the biometric and they got the EAD, but whoever applied in March, they stuck in the process. It's not their petitions is not resolving steps. So, do you have any information what kind of necessary action take action on this one? Any steps are new? Any steps?
You can always go to uscis.gov and we can file an e-request, which the case would be outside of normal processing times. We can also call the customer service number, which we discussed a minute ago. And you'd want to try and get a hold of a level 1 officer to see about, what the problem is about to resolving the delay in processing. And then if you were able to get through to level 1, then if they reply back with an option where you could upload documents or things like this for further information, then you would want to do that to try and expedite the process. But it's very much disorganized. I don't know if there's really much of a procedure in place for USCIS officers to go back and maybe fix these issues, because you have to remember, Venkat, you're in Houston, I'm in Dallas. That's two completely different offices used for biometrics. And, if the appointments aren't available within that time, then you're asking the officers to, on their own accord, to go back and make sure it's scheduled. And, with such delays and backlogs, I can see where, we might have some officers who are pretty proficient, or there's maybe less of a backlog if you're in Nebraska, versus, here in Texas, where we have a higher density of an immigrant population that needs these services. So based on all of that, there's a lot of factors that can cause certain locations and certain groups to be delayed more so than other places in the country.
Okay. Lucas, we got one question from Narendra. How long it will take to receive the EAD card after fingerprints completed? Is there any timeline
for H4 EAD?
Yes.
Typically, I would say right now, if we filed one in June, what is that, about 4 months total, 4.5 months?
After
fingerprints? After filing. Yeah, after filing. And that was in June, so that's what we've been averaging here lately. But the ones we filed in March, there's still some that are just pending and kind of in limbo. So if you have a case that's filed more recent for EAD, it seems like it's about 4.5 months. But that's just a guesstimate at best. It's just kind of the trend we see. But we still have, and I've spent a lot of time trying to get a hold of officers to try and fix this for a number of people who we filed cases for in February, March, and April. It's just a side effect of everything else that's gone on with this pandemic.
Yeah. I think the H4 EAD process, the biometric is holding the process, enter the process. Hopefully the next administration, presidential administration, remove the fingerprints, maybe everything will be smooth.
Well, I actually received a few notices here for cases we filed in March where they've waived the need to go for biometrics, that they have the biometrics from previous case still on file, and they were able to use that data. So, some cases, I think that they're trying to even implement that to speed up the process.
Yeah, I think this H4 EAD H4 the biometric got in 2019, right? So whoever H1 got approved in 2018, they don't have the biometric in United States. So if they applied now, maybe if they extension or they applied the H4 EAD, they have to go for the biometric. It's true, or maybe they given in a consulate while pursuing the visa. Is this okay to get the biometric from their consulate?
Typically, you're talking about two different distinct agencies. So whatever you would do when you fill out your DS-160 and go for appointment interview would be within Department of State. And when you come back here to this United States, so let's say you went and you're abroad, you come back and you have your H4 stamp and you enter the United States with your I-94 and you have a duration of 1 more year. Well, at that time, when you come back here, then you would apply with USCIS for your EAD. Now, when you do that, you're probably going to be required to go ahead and do biometrics because of the USCIS guidelines and procedures.
Okay. So, Lucas, we got a question from Teja. He got I-140 approved in EB2. Now he with different company. The current company is saying that they will apply in EB3. Is that okay? Will there be any impact on time of EB3 GC process it downgraded?
Teja, I'm glad you asked the question. And yes, there's been some changes here within the past couple of weeks that will impact this. USCIS has implemented a new policy that makes it a little bit more difficult to port your job from one employer to another and preserve your priority date from one I-140 to another. So what you would want to have to do is really have the attorney examine and know the specific job requirements and how they match and can be related to be something similar. So the adjudicator's field manual, the AFM, that the USCIS would rely upon when deciding whether or not to port over the new date, it's going to be more specific than maybe 2 months ago. So what this means is whenever, you might have to have a strategy of filing the labor itself is where could be an EB2. And then whenever you file I-140, you would just choose, a downgrade option to get the EB3 category. So there's a lot of different factors involved with this, but it is possible. But unfortunately now there's a little bit more of a scrutiny involved when the service is looking to port over the priority date.
Okay. It means if any I-140 holder, maybe H1 holder, and previously they applied LCA and EB2 and applied in I-140 and EB2, if they change to another company, they cannot apply in EB3, right?
No. So the labor itself, the 9089, is not specific to EB2 or EB3. What we have to do as attorneys is we have to determine when we file, does the labor that we file, the ETA, does it meet the requirements for USCIS to determine whether or not the position qualifies for EB2 or EB3. So what this means for EB2, you would be looking at a master's degree or a bachelor's degree with 5 years of experience. So if you do a labor and the ETA, where you say the minimum degree requirement would be an associate's degree or a bachelor's degree with 2 years of experience, that's not going to qualify for EB2 when you file the I-140. It doesn't mean that the labor itself is not valid. It doesn't mean anything else. It just means it won't meet that requirement when you file with USCIS. So vice versa, what you would want to do if you're filing EB3 with USCIS, you would want the labor to still meet the requirements of what the position would be, so the position could qualify for EB2, or you could choose to file at EB3, but you would want to have that bar set high. And then if you don't use the EB2 filing, you could still do EB3, or in the future, if you want to upgrade, then you could upgrade to EB2 from EB3, if the final action dates move quickly or something else happens.
Okay. So, Lucas, we are discussing about I-140. I have a couple of questions on I-140.
Mm-hmm.
So, if first we apply the perm, right? The once approve the perm, we will apply I-140. Let's say if any H1 holder at reaching to the 6 years term, so maybe they have only the couple of weeks at the time he had approved perm, will he apply the H1 extension with the perm?
So as long as the perm is not expired, and what this means is that either it's a valid perm, which they're valid for 6 months, so the ETA 9089, or if it was filed before, but like the I-140 was denied for any reason, that's valid to go ahead and extend beyond the 6 years. You don't have to have an approved I-140. So under AC 21, you have, as long as you have a certified labor, that's the most important thing. Now, some people the reason we get, to the 6 year and people need to have that process started, the reason is there's also an exception. Let's say your labor is in audit and it's pending, or something happened to Zoom was denied, but the whole labor has been pending for more than 1 year. You can use that and forward that whenever it's time to extend beyond the 6 years. So there's certain other factors and circumstances that might merit you qualifying to go beyond 6 years, even if you don't have an I-140 in your hand.
Okay. The same question on the H1 extension based on the perm approval. Let's say if H1 holder is I-94 expiring December 3rd. So they want to apply the H1 extension today. Maybe they have the FedEx tracking number. So maybe the FedEx will reach by tomorrow. Mm-hmm. Right? We sent today, it means overnight, it will ship tomorrow. So by the time the USCIS receive the receipt, but it will not generate the receipt number, H1 extension receipt number.
Correct.
The still valid for I-94, will he stay in United States?
Correct. So USCIS factors in the day you mail the petition itself. So this works for transfers, extensions, all the same. So let's say that I'm going to file a change of employer and your start date is today, or an amendment or something like this. As long as I file the petition on the same day as when you start, that's acceptable. Okay. Also for the expiration of the I-94. Now, it's not good to wait till the last day, but you can file the day of expiration if it came to that close, and it would be accepted by USCIS. Now, when you have a certified labor or ETA 9089 form, you're going to be able to extend 1 more year rather than the 3 that if you would have had the I-140 approved. But at least it allows you to go beyond the 6 years, and it protects you that way.
Okay. So we got another question from the Teja. Maybe Teja had H1 for the next. I'm taking the example. Teja had H1 extension by 2022. After 1 year, he moved to another company. His wife got H4 EAD for the 3 years. After move this the new company, so his wife is it okay to work on the previous H4 EAD, or he want to apply the new H4 and get the new H4 EAD to work?
I think it's always best practice to go ahead and always file everything at the same time. So if husband and wife, are both in sync at all times. And also, what's important for H4 is that you have an H-1B petition, and the beneficiary of that H-1B petition is maintaining their status. Okay, so you have to have those requirements to legally be on H4 and maintain your status in that category. So best practice is always file H4 EAD at the same time you're filing a change of employer. And that way we can always try and make sure that the dates are always in sync, because there's a lot of times where it's an extra headache where someone forgets, but my H1 doesn't expire till 2022, but I didn't realize my wife, her H1 or H4 expired November of 2020. There's always something like that, and it's always, people find out after the fact. So best practice, go ahead, file everything together, and then that way you're also it gives you the option to extend beyond, file that extension early so you can get extra time on that H4 EAD.
Okay. Lucas, we got another question from Venkat. He applied the H1 extension and regular with the labor approval and pending I-140. Is it possible attach I-140 approval when moved to the H1B extension and premium process?
No. So what USCIS looks at is at the time of filing. So what requirements or what evidence did you have at the time of filing? Did you qualify for this benefit when you mailed the package or petition? So you would have to be a very, very odd circumstance where they would accept it at that time. So typically what we want to do is have placeholders in place to where, someone can, there's always circumstances you could argue, such as, we're here in the pandemic right now, or other things where traditionally travel's not available. But as far as I-140s go and approvals after the fact, you typically would need to have that benefit at the time of filing.
Okay. I think, Venkat, your question, you got information from the Lucas. Lucas, we got another question from Suresh. He is on H1 and October 2020 applied for the adjustment of status. Now he had an offer from the client to join them immediately. Can he join them using the H1B transfer? Will there be any issue since he filed the adjustment of status?
No, there won't be any issues. And, I'm sure his I-140 has already been approved for more than 6 months. So the current employer probably won't be able to revoke the I-140. And after 6 months of the adjustment of status pending, you can, request your new employer to sign a supplement J. So, at the end of the day, the most important thing you can do is protect your H-1B status. And depending on what your priority date is, if your priority date's like 2011 or 2012, it's still going to be many years before the GC is actually available under our current processing time. So you would, barring any miracle for, the next 2 or 3 months, we get great news that, all the backlog's taken care of, it's still going to be a while. So you want to make sure you protect the H-1B status and, keep all the options open to maybe port over the adjustment after 6 months.
Okay. I think he is good as long as his previous employer maintained the I-140 until revoked.
Well, you can't revoke the I-140 after 6 months. So even if he leaves, the employer can't,
Lucas, I hear maybe employer might be revoked the I-140 after 6 months, right? No?
So under AC 21, one of the new regs that came about it is that you, as far as like extending beyond your 6 year, you can still use that I-140 to do so as long as you've had it more than 6 months. Now, as far as like using that to continue employment and adjust your status, you'd probably want to have, you would need to have some other ability to go ahead and do that for the future employment with the GC. But yeah, after 6 months, the policies, employer can't go back. So the whole provision, not to go too in depth with what the policy is, the whole reasoning behind this is you want to have it easier for people who are here at H1 to switch employers. You don't want to be stuck under an employer that you might not like, or that, the circumstances of your employment it could become an abusive situation, or you might not be able to make as much money as if you worked somewhere else. So the provisions in the regs are set up to where it's easy for you to port over and change employers where you're not tied to that one specific employment.
Okay. Lucas, we got another question from the Teja. The same. Already we discussed about this one. IFR is asking that how many years of 1 minute. Yeah, sorry for. So how many years of H1B approval an employee can get if he working through third party? Just we discussed and starting of show about the IFR. Maybe you can give this answer.
Yeah, so everything will remain the same now. As far as that goes, you'll still be able to get, hopefully a maximum of 3 years if your employer requests it. So, it's, we were stressed a little bit this past couple of months, especially with the wage increase and the potential limitations of the new regulations or the new rules with the IFR. But, luckily all that's been suspended at this moment. And that's something, hopefully we can get back to business as usual, here in the next day or two.
Okay. Lucas, we got another question from Bhaskar Vallabha. So he wanted to clarify one thing regarding his application. His form is applied by, I think, current company in 2012 in EB2 status. Current attorney is telling me that the Indian master 3+2 is not equivalent to the US master, and my application can be risked and cannot go back to downgraded nor apply I-485. He's asking, are there any good option for me? Or?
Well, I mean, you need to have a master's degree, and depending on, I rely on evaluators to tell me, because I don't know offhand all the rules, but I know, a bachelor's, 3-year bachelor's doesn't necessarily equal a bachelor's degree here in the U.S. Certain master's degree might not either. So I'd have to be honest with you, I'd have to review the education credentials with my evaluator to determine if that's the case. But if that's what the attorney says, then yes, that if USCIS approved your I-140 in error, there's a great risk of, maybe having everything denied, bringing that to the attention, trying to downgrade or do some other things. So, that unfortunately, that is something that might be a bad situation, the way it's set up for you. So I would recommend, maybe discussing that in detail with the attorney, going over any options that there might be, and, probably starting with your employer now to go ahead and start the process, if you haven't already, to file a different labor and I-140 as a backup. So if that does come to light and you get a notice of intent to revoke the approved I-140, you have a backup plan in the works, so you don't lose your status, or you can't extend beyond, the 6 years like you already are at.
Okay. Here, just I want to discuss about the EB2. Any H1 holder, if they want to apply in EB2, the general condition is maybe he must do master in United States or equivalent to the United States bachelor plus 5 years of experience so that they can apply an EB2, right?
Correct.
That is. So if you fall this condition, maybe if he fall this condition, maybe I'm not sure. You give already alternative plan to check with attorney or maybe check the education evaluation. So Lucas, it means Suresh is saying that still he's not clear what will happen to adjustment of status since he did not pass threshold of 180 days pending, and I transferred my H1B. We discussed before. Suresh, he asked, right? He applied the I-140 from the company A. He transferred to the company B. So at the same time, he applied the adjustment of status from the company A.
Mm-hmm.
So after apply the adjustment of status company A, he moved to the another company B. Let's say if the previous employer have the ability to withdraw the process within 180 days.
So
you told already beyond the 180 days, the employer could not be revoked the I-140. So what if still I-140 within the 180 days period?
So whenever you filed the adjustment of status, that's going back with the I-140, that's for future employment. As long as your adjustment of status is pending for 180 days, anytime when the final action date becomes current, right? So your final action date is probably still years out under the current timelines. Once your final action date, becomes current, even if you're an employer C, D, E, F, or G, whatever it might be, as long as it's been pending for 180 days or the new employer can just file a supplement J to say that this is, and the job duties and responsibilities have to be similar. It has to be a similar job. You can port the adjustment to that new company. Okay. It doesn't. You don't have to actually be under H1 or anything like that. You can port after the 180 days.
Okay. Suresh, still, if you're not clear, maybe you can send an email to the info@bgimmlaw.com. So Lucas will give the valuable information to you. Lucas, we got another question about the H4 EAD. H4 EAD. He applied the H4 extension EAD. It's been more than 5 months, but haven't received the biometric appointment notification yet. So he reached out to USCIS and their response is to wait. Anything else we could hear other than the raising service request with the USCIS? So he's saying that they did not qualify for the expedite request with the job offer. So can we file expedite request or not?
So here's the most important thing I want to convey. I had one of the viewers or listeners to our show from Telugu NRI Radio. He called this last week, and he was informing me that, hey, this happened where my H4 for my spouse was filed back in Jan, and we never received the receipt. We had to call multiple times, and finally in March we received the receipt. So then we never received biometrics, so we kept calling, and he said this last week that they received a denial notice in the mail because that they missed their biometrics appointment. So you have to, really stay on top of it and call as much as you can, because you have to remember that you have your service center who's handling the H4 EAD here, and they're just referring the appointment notice to each field office who's going to conduct the biometrics. So, you're relying on people who might or might not be going back and making sure everyone, is covered. So it's the best thing you can do is to speak to a level 1 officer, or maybe request a level 2, or have an attorney if an attorney helped you file your case, have them help see what they can do to get the biometrics done, because there is a risk that if you never receive notice and you miss the biometrics, obviously USCIS will deny that application.
Yeah. Even so, I see the couple of questions about the bill S386. It means a couple of websites are posted is a bill passed, but you said did not see any news from the bill. What is a senator bill? What is a bill? But he's asking that there is a little bit. I don't know. Just I'm hesitating to ask this question. Look like Lucas is sad today. That is called Facebook. So I'm not sure. The Lucas is busy the past couple of weeks. So that little bit today is the evening. So I think you are pretty busy. That's why your face is showing look like it's a little bit sad.
No, it's not sad. It's just been long days. For the past probably 3 or 4 months, it's been very, very busy. A lot of these changes. I just want to say this: any case I work on or anything we do, I really put myself in the shoes of the people I help or that hired me to help them, and it's been very stressful. So if I appear tired, it's because I am tired, because it's you get so much stress and worry about what's going to happen. How is someone who's waiting on their GC and now they have to file H1s every year, or all this stuff. It's been a very difficult time, especially but today hopefully we have good news. Hopefully yesterday we had the court suspending the IFR, and hopefully if everything's true with the news about the Senate bill. I mean, I haven't heard officially yet, but if that passed, that's great news, and hopefully the president would sign that into law, because that would help everyone out tremendously.
Okay, I think Bill read. I think you got the answer from the Lucas. Yeah, you got answer from Lucas. Lucas, we will take the last final question from the Srinivas Gudipati. He applied I-485, 765, I-3131 on October 23rd under EB2 category at the Texas Center. Till now, he didn't receive the receipt. How long it will take? Already we discussed. Just you can.
Yeah. So under Supplement J, at the Texas Service Center, you should be receiving this week, and then at the latest possibly next week. If you might want to check and see if the check's cleared or your money order's cleared, and if they did, receipts usually follow within 3 to 4 days after that.
The one single, if checks is redeemed, so you will get sooner the receipt number, right?
Yeah, and also on the back of the check, if you use your own personal check, usually they'll write the case number for the adjustment case on the back of the check.
Okay. Yeah, we fast to 5 minutes over the 5 minutes or seven. I think this week is a lot of good news for the H1 holders.
Yeah.
The IFR, maybe the bill. The country quota bill, if passed, very good news for everyone to get the green card. So yes, Lucas, we discussed a lot of things on H4 EAD and F485 and IFR. Apart from this, do you have any other information to share?
Don't have anything else to share this week, but like we say every week, I'll end on this note. Just make sure you follow and like Telugu NRI Radio on Facebook and our office on Facebook, BGM Law. And we try and post any updates as they happen and share the news. So if you can, just follow and like our page, and also share with your friends. And, we appreciate the questions and the input that all the listeners have, because, we're, as again, like what Venkat always said, the purpose of our show is to serve the community. And it takes members of the community to participate with us on the show to help other people out as well, because so many people might have the same questions. So hopefully, touch wood, we can keep getting good news.
Lucas, closing the show, just I will ask the one question from the Krantik Moore. Is master degree for profit university is an issue for the EB green card? I think he know it is for the H1 master quota. At the time of graduation, university is accredited, and what if losses later? Will the degree will be still considered? He want some valid input from you.
You'd have to ask me one more time.
Let's say he pursued the master degree in United States. At the time, the college has the accreditation. Later, the accreditation, it got lost. So what is the situation to apply the green card process?
So when you look at, if you're talking about like a Northwest Polytechnic University or Silicon Valley University, if it was accredited when you received the degree, then that would account for accreditation. Now, for EB purposes for GC, that should be sufficient as a U.S. master's degree. Now, for cap exempt for master's cap for the H-1B cap, that you'd have to have at the time you graduated, you'd have to have an accredited university. So if there's anything, I think that's what's the question. But if there's anything more specific, you can definitely just ping me offline or send me an email, and I'll try and help with any more specifics.
Yeah, thank you. I think last question, Santosh Kumar Pola. Can you discuss me more about the HR 1044? The Santosh, already we discussed about this, the bill S386. Maybe you can see this video later. As of now, we don't see any confirmed information from the official website. Congress website bill got approved. Maybe in future, next week, we will continue this show every week, Wednesday, 6 p.m. Central Time. If any information on this bill, we will post, or we will bring this information into the next show, and we will discuss a very detailed and elaborated. We will try to provide the elaborated information to all immigration holders.
And it would be irresponsible unless we knew firsthand and verified the facts for us to speculate on that. So we just try and we're going to hold off with any information or news, even if other people are tweeting this, until we get actual notification or from a valid source. So we're not sharing information that might be inaccurate. That's the whole purpose behind that.
Yes, we are trying to share accurate information. So please wait for next week. If any information come across, we will definitely share to all the viewers. Yeah, I think we fast 10 minutes, Lucas. We can close now. Thank you for today. And thank you very much, everyone who participated in this show and posted the questions. And please, maybe you can continue to tune Telugu NRI Radio Facebook Live and get more information on USA immigration system. So we keep saying every week, if you have any specific topic you want to know, or if you have any specific scenario you already fall in, if you want to know more information about the USA immigration system, just post your topic on Telugu NRI Radio Facebook or Burgos and Garritson Facebook page, or you can send an email to the info@bgimmlaw.com or info.telugunradio@gmail.com. So we are ready to provide the accurate USA immigration information. So thank you each and everyone to join today. And thank you, Lucas. You're participating every weekend and you're coming to the Telugu NRI Radio Facebook and helping to the Telugu community or Indian community on immigration system. We are very thankful to you. So then we can close today. Signing off from my side. Thank you, Lucas.
Thank you. We'll see you next week.
Yeah, thank you.